anytime I'm teaching criminal law, I feel like somebody can be on my brain to understand it. Because criminal law is very, very technical. I enjoy the course so much. So what I'm trying to tell you that for the fact that you didn't see death or rape as if it's a coming, doesn't mean that it doesn't exist. So remember what we are defining. Are you seeing the definition now before you? So we are saying that it's volitional act, and then the knowledge of these circumstances. Circumstances here that the reasonable man should know that raping a girl could lead to death. That raping a girl could lead to what? Pregnancy. Unwanted one, not that pregnancy is bad, but premature. Then death.
You see, he's not behind it. No lawyers can do this.
On our first lecture video for the first semester on criminal law, we discussed about the crime and the nature of criminal law. Then on the second video, I took you further to the element of criminal law, where we discussed the actus reus and the mens rea. And now, this is the part 3 of our lecture video on criminal law. And what to set to discuss today is in line with the last promise I made you on that video. We're going to talk about the types or the aspects of intention. I don't know if you are aware that if somebody has killed somebody, the killing is the actus reus, but the killing ipso facto is not enough for you to convict that person. You must show further proof that the person being killed was actually killed by the intention of the accused himself. So it's not just enough for you to say that somebody has been killed without supporting the proof that the person had the intention to kill that person. So this is where the aspect of mens rea comes in, because most of the times people could kill not because they intended it, but because they were reckless, they were negligent. And of course, you know, the law is not Father Christmas. The law and the court are not there to be, you are not there to be playing with you. So these are what we are going to treat on this video. We are going to know to what extent then can you say that there is absence of intention, and then if there is absence of intention, was the accused reckless? These things are very important because this is what will give rise as per whether the person should be freed on the absence of intention, as per whether the person should be convicted on basis of recklessness, on basis of negligence. All of them has similar punishment or similar responsibility that comes with it. So on this very video, I'm going to painstakingly take you on the aspect of intention, on the aspect of mens rea, provide you with authorities that illustrates how it works. And then at the end of the video, I'll give you further guide as per what you are to expect from your lecturer as far as this topic, first semester on criminal law, is concerned. I'm very passionate about this topic because if you understand this topic, everything else in criminal law, both for first semester and second semester, is going to be more easier for you. So I encourage you to remain active and watch this video to the end. By the way, my name is Kingsley Ifeanyichukwu. As at the moment this video was posted, I'm currently in my 400 level. And what I do on this channel is to help law students, my fellow potential lawyers, in the challenges of becoming tomorrow lawyers. And my whole motive is that tomorrow all of us will be grateful of the future we are building. Please, if you have not liked the video, I encourage you to like. If you are interested in academics, law in particular, subscribe, because we post video most often on Friday, Saturday, and sometimes on Wednesday. And turn the notification to all. The import of that is that whenever we post a video, you'll be the first set of people to click and watch and see how that video will help you. But what we are treating today is the aspect of mens rea. The mens rea, in its simplest understanding, is the guilty mind. So what this thing is saying that even if there has been a killing, there must be something that the person should have in mind to have killed that person. And the general principles of law is that the devil knows not the heart of men. So even the court, even the lawyers doesn't know the heart of men. They can only adjust, or they can only think on what the person have in mind based on the surrounding circumstances and behavior of such a person. Are you with me? So what we are treating today now is the aspect of mens rea. That is the types of mens rea. What are the ways mens rea could be shown to exist or could be shown not to exist? The first thing is intention. The second thing is recklessness. And then the third thing is negligence. So when we talk about intention, before I give you authoritative definitions, intention basically refers to that which you have formed in your mind before executing a particular thing. Please don't misplace intention with motive. They are different things. Motive is the reason you are doing something or the reason you did something. But intention is the pre-planned action or pre-planned thoughts about that thing. I don't know how to paint this scenario so you understand the difference between motive and intention. But know it that motive is not a basis. Motives cannot be a reason to free you or to convict you for a crime. In fact, motive is irrelevant in criminal law. Motive can only play a role when you are being sentenced, like when they are imposing sentence on you. For instance, if the law provides 10 years imprisonment, motive could come into, if the law provides that the maximum punishment for rape is 14 years based on verbal acts, like the maximum could be, you will be liable. The law often say you will be liable for a term of 12, 14 years imprisonment, meaning that there could be either 14 or there could be minimum of 14. So in this case, the judge has discretion to give you 14 years or to give you 12 years. So if you committed that rape, I don't want to use rape. Let us assume a mother steals a loaf of bread for the sake of his child that is dying of hunger. For the fact that the motive was to feed the guy or the child of hers, does not mean that he will not be convicted or he will not be arrested. Are you getting me? Motive is irrelevant in criminal law. That is what criminal law told us. The motive of you doing an act or not doing an act is irrelevant. But the intention there is that before going to that shop, he knows that that shop is not her. Do you understand? But he went ahead to steal something. Her intention was what? To steal. Her motive was what? To feed her child. Are you with me? Like, have I clarified motive and intention for you? The motive of the woman was to steal a bread to give her child. The motive was to feed her child, so to say. But the intention was to steal a bread. I started by saying that a mother went to a shop to get a bread without paying to give her child. The act of going, the intention was to steal. The motive of going was to feed her child. They are different things. So you cannot say because it was, to feed her child, he didn't longer commit a crime. Or you come before the court and be arguing sheepishly like a lawyer, saying that since he was for feeding of a child, he will not become. No! Objection, my lord. The intention is clear, to steal. So whether it was to feeding a goat or feeding a child is irrelevant before this honorable court. But on the other hand, when the judge is about to sentence, if the law says that for stealing a loaf of bread is minimum or maximum of 20 years imprisonment, the judge can give him 10 years imprisonment. The judge can give him 15 years based on the motive. The motive was to feed and not to actually just steal for the sake of stealing. So motive will only come into play in criminal law when it has to do with punishment and sentencing. Apart from that, motive is irrelevant. Take note of this, because on the end of this video, I'm also going to tell you more how to approach it, like I promised. So at the end of this video, when we shall discuss that, how it works, that is when I'm going to give you more feedback on how you are going to approach your problem question on this. Now, we are going somewhere. I'm talking about intention. So it's me now telling you that intention is the volitional act performed with the knowledge of its circumstances and desire to achieve its consequence. I will repeat myself. Intention is the volitional act performed with the full knowledge of its circumstance and desire to achieve a consequence. Assuming there is a girl you are admiring. You approach that girl, you check that girl, and the girl refused. Then you begin to, due to your excessive urge towards that girl, you then want to achieve it with all means. Then you plan to rape that girl. The volitional act here, when we say volitional act, we mean voluntary act. Don't allow people to confuse you. Volitional act means voluntary act. So the voluntary act now is that you are now planning to rape this girl. Knowledge of the circumstances here is that you know that the consequence of raping that girl will lead to what? Premature pregnancy. Will lead to what? Premature HIV. Oh, is there anything like premature HIV again? Will lead to what? HIV. Will lead to what? Premature death. Are you with me? So you already know that this thing could cause death, this thing could cause HIV, this could cause early pregnancy. To a law student that is still in his first year, you want to rape her, you want to dash her belly so that you crush her dream. These are what? The knowledge of surrounding circumstances. You already know. Anytime I'm teaching criminal law, I feel like somebody can be on my brain to understand me, because criminal law is very, very technical and I enjoy the course so much. So what I'm trying to tell you that for the fact that you didn't see death or rape as a coming doesn't mean that it doesn't exist. So remember what we are defining. We are defining intention. Are you seeing the definition now before you? So we are saying that it's volitional act, and then the knowledge of his circumstances. Circumstances here that a reasonable man should know that raping a girl would lead to death. That raping a girl could lead to what? Pregnancy. Unwanted one. Not that pregnancy is bad, but premature. Then death, hips, gonorrhea, HIV. So all these things are what you should know by virtue of being a man. And there is a presumption. Universal principles of criminal law is every person is deemed to achieve the natural consequence of his action. So even if you think that you didn't see rape coming, you didn't see death coming, you didn't see syphilis coming, you didn't see gonorrhea coming by you raping her, it is presumed that you should know the effect of raping a girl without her consent, what it could lead to. This is what we say, the knowledge of surrounding circumstances. And then the desire to achieve it. Are you seeing how we are illustrating the element of what we do, the description we give? We say that you must also have the what? The desire to achieve it. Very important. So the desire to achieve it, meaning that you are now taking a pre-step actions to achieve what you have intended. You have not just foresee raping of Ada, but you have made plan on how you are going to rape Ada, medium we are going to rape Ada. In this case, intention has been fully what? Conceived, and because of that, the law will be harsh on you. This is for rape. This thing would also, you can interpret every example I give you with respect to what? Murder. Because assuming you are killing somebody or you're about to kill somebody, you must plan, you must put a gun. If you are going for terrorism, if you are going to rob somebody, you must package your gun, you must have devised means you are going to rob the bank, and every other thing that happened, you must have intended it, whether you knew it will happen or not. What we say by intention. Now, because I promise you, we shall be analyzing with authority. There is case of Hayam against the Director of Public Prosecution. It's a 1974 case, I remember. It's a 1974 case. I will basically give you a smooth shooting fact of this case, so that if you would like to read further, you will then go and understand it. The fact I'm trying to do is to break the fact, because the fact is very complex that it may confuse you, but I'll just use what is obtainable that alludes to the fact. So what happened in that case is simply because a girl is too jealous. You know, women can be jealous, both in relationship and in marriage. They're always jealous. Mrs. Hyman was jealous. He felt that his husband or his potential boyfriend, they are in a room and doing otherwise with another lady. So he went and bought a fuel and then poured it around the building and then lighted it, and the house caught fire. And you know what? The end will be story for the gods. You know what will happen? So there was a death, or there is death, or there were deaths. So what then happened is, you can imagine how sheepishly life can be. The lawyer and the Mrs. Hayam. Mrs. Hayam then came and told his lawyer, and they argued that he didn't intend death. Oh God. You didn't intend death when you pour a fuel around a building and light it up. What else were you intended, if not death? So he just said that he was inclined with jealousy and all those things. Would I say he was trying to scare them away, or was making them to cut that their enjoyment short? But the court said no. No. For every person who is pouring fuel in a building, that you know human being were existing there, and you light it up, there is nothing else you are expecting other than death. So, according to the learned judge in that case, the House of Lords held that foresight of death or grievous harm as a probable consequence was enough to establish intention. What this case is saying that if this woman have engaged in this kind of act, there is no way you will tell me that he didn't intend to kill somebody by doing such an act. And even if he didn't intend, the court will apply it from. Remember, the rule is that even the devil knoweth not the heart of man, according to Lord Devil. So, because we don't know the heart of man, the only thing we lawyers and judges can do is to apply something based on your conduct. And the conduct of anybody that is pouring fuel on a building and lighting its fire is nothing but death. So, there is a natural consequence. So, death is the natural consequence of the act of Mrs. Hayam. And the court presumed it to be so and convicted him because he had intention. Another thing I want you to know is that we are not going to treat section 24 here. Well, section 24 is the basis of intention. The reason is that section 24 has a lot, and not something I can cover on this video. So I'm going to dedicate a specific video where I will take you people on that and further give you people cases and tell you people how to apply it to your lecturer. So what I'm going to focus now is this aspect of intention, recklessness, and negligence, and how they are all apply. So if you are waiting for this video, tell me to make the video, because I don't make video people don't watch. If you are interested on it, just comment and tell me to continue with it, so that I will make video on that aspect. And now let us continue. In another case of R against Moloney, what happened in this case is also as simple as what we see in the other case, but I will just go straight to the judgment in that case. So the court in that case held that the House of Lords once again ruled that foresight of a serious harm does not automatically mean intent, refining the legal meaning of intention in murder cases. So what the House of Lords was trying to do there, they was trying to make a kind of caricature of the judgment in the case of R. Hyman against Director of Public Prosecution. The House of Lords was saying that foresight of serious harm does not automatically mean intent. So in R against Maloney, which was a 1985 subsequent case, the court is saying, under section 316 and section 319, the provision is that there must be a grievous bodily harm. And this is why I told you people I'm going to cover section 24, because section 24, even 10 video cannot explain it, because it has a lot. There are conflicting judgments. As you can see now, in case of Hyam against Director of Public Prosecution 1974, the English Court House of Lords held that this human, there is a foresight that lighting up a building could cause death. But in the further case of R against Maloney, the court held that serious bodily harm or foresight of a serious bodily injury is not enough to presume intention. The reason, I know you may be confused at this point what I'm saying. Or what I'm saying is because what I'm saying in essence is this: if death happen, if something happen, let's use death, murder for instance. If murder happen, most often the accused will always claim that he didn't intend to kill. But if you didn't intend to kill and you use cutlass and slash somebody, the court will be looking at what you did. That is the bodily harm or the act you have committed itself. Let me say you then use cutlass and throw at somebody. It is intended that when you are throwing it at you should know the grievous bodily harm you are intending to cause. And if you have if the prosecution have proved that you throwing that thing could cause, or even if without the prosecution proving, the court is a reasonable human being, judges are human beings, they will check the weapon you used, they will check what you threw, they will check what you did. In the case of Awudomoro and the state, if somebody throw a burning stove with kerosene, you throw it at somebody and you come to the court and open your mouth and say that you didn't intend to kill when that person caught fire. So the court was like, Obota JSC, my beloved jury, said, how can you throw a burning stove at somebody with kerosene and the person caught fire with the food and everything, and you say that you didn't intend to kill? Court held that throwing a burning stove at somebody, there was intention to cause a grievous bodily harm. And if death happens, it must be imputed to you that you intended to kill. Are you seeing what we are trying to say about intention? We are just trying to say that for you to be a successful charge of murder, successful charge of rape, successful charge of stealing, the person must have intention to do that. And to do that, we human beings, we are not God. We don't see people. We are not omniscient. Neither are we omnipresent. The only thing we can look is at the act itself. What you use, the weapon, the body, the part of the body you throw the thing, the part of the body you slap, the part of the body you wounded. These are the area we are going to check. And if you check it, we can then draw inference to say that you had intention. So this is what this whole case is all about. And this story I'm telling you, if you think I'm wasting your time, just know that this story is what you are going to tell your lecturer if you want to pass, or less if you don't want to pass. In the further case of R against Woolen, which was 1999 case, the court held that a result is intended if it is virtually certain consequence and the defendant appreciate that. So what the court in this case is saying that a result is intended if it is virtually certain consequence and the defendant appreciate that. That's why I keep telling you that intention is an aspect of law that has created a lot of confusion between jurists and the lawyers. Some authority will tell you that the person that is throwing it must appreciate that death will result automatically. Then some authority is saying that even if you didn't intend that death will result, for the fact that you acted so extremely recklessly could be inferred that you have the intention to kill. So what you have to do now as a law student or the law watching me, the question is not your business to check whether which position is correct and which position. Yours is to present these whole cases. Tell them like I'm doing to you. I will read these cases. There is nothing that have prevented me from picking a particular case and teaching you this. But I'm presenting the divergent view because I love you. Because I want you to see the different perspective. Because everything I did when I wrote this criminal law was to provide this perspective, and I'm not regretting my results. So why will you regret your own? So you present it. You tell the lecturer this side. You present it. That's why I say a law student should not take side. Be objective.
Law confusing? Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimplelegal.com or simply scan us on Google to discover how easy law can be.
I dissect this principle, If you must take charge, if you must take side, at the end, you make your own submission and agree with particular authority. In the further case of Obani against the state, pay attention, this one is a Nigerian case. The principle established there is very relevant. The Nigerian Supreme Court said that where the accused inflicted severe assault resulting in death, it was intentional with knowledge that death or grievous harm was a probable result. So, in this case, the accused inflicted a grievous, like the accused was just busy inflicting harm on somebody. And then the courts then say that if you are doing all this, you possibly you slap. When we shall trace section 25, I will give you a case even where they slap somebody, the person hit his head on the tar road and all these things. If you are doing all this, you may not have intended to kill, but all this is infliction of evil, infliction of heartlessness on the person. If death results, it could be imputed to you that you intended that death should be the natural consequence of your act. It's as good as that. So what I'm trying to say is to teach you how to discover intention. And by virtue of the authority we have looked into, we see that what matters is act you are committing. And if the surrounding circumstances show that whatever you are doing could lead to death, death will be imputed to you, whether you had the intention to kill or not. Then another case where the Court of Appeal also made another principle, which I want you to know. In case of Indirect and the state, the Court of Appeal affirmed that to succeed in the charge of murder, the prosecution must prove intention to cause death or grievous bodily harm. So under section 316, section 319, what is required under these two sections? One talk about the prohibitions, the punishment. One talk about the outline ways you can be deemed to have killed or taken life. One of the things that can suffice, one must suffice, is death or grievous bodily harm. So it is either you intended death. For example, when you carry a gun like this and shoot, there is no doubt you intended death. Then when you are hitting somebody, you are beating somebody, you are slapping him, you are hitting his head on the wall, what you are looking for here may not be death, but grievous bodily harm. You want to wound that person so that when that person remember you, it can link you up to some wound in his body. Then you will be grateful. What you are looking for is grievous bodily harm. So even if death arises in that situation, the court will presume that grievous bodily harm to amount to that you intended to kill. So this is what intention is all about. Intention is trying to tell you to what extent the court. Remember, without this intention, an accused can go free. Are you with me? If you didn't prove intention, whatever the person may have committed, the person will go free. At most, we shall consider recklessness and negligence, the person could be convicted for manslaughter. But manslaughter is not death. Manslaughter, although the maximum punishment is life imprisonment, but the person could be sentenced to 5, 10, 6. I will even see 3 years because it's manslaughter. So manslaughter, the maximum punishment is life imprisonment, but the court have discretion to do that. I've seen only few cases where the judge gave manslaughter life imprisonment. Mostly it has always been little punishment. So that's why the prosecution will always push for murder, because murder should be the ultimate, one that will come with sentence for death. But most often they usually don't succeed because of the lack of proof of intention. So intention, as far as criminal law is concerned, is a very, very important aspect. So what I want you to do now, remember I promised you something about how we are going to counter this in your problem question. So how this question is going to come is, you should be expecting a situation whereby they will print a problem question. First of all, in my own school, how this thing came about, my lecturer lifted up a case. I think it was what is the name of this case? I have forgotten at the moment, but he lifted up a case which was decided by Sentus Mweze of blessed memory, Justice of the Supreme Court, from Enugu State and Soka in particular. There's something about that judge, there's something he said in that case about intention. So he lifted it up and said we should analyze it, section 24, in line with this judge's pronouncement. But that was where I invest everything I know about intention. Trust me, my head was proving like this. My head was burning with fire. on cases in intention because my lecturer hammered on it. So if you are in my school, I believe this is still what my lecturer is going to do. So he will lift up a case that discuss intention and then tell you to analyze it. So it was purely essay. But then, to some extent, there was also a question that comes with intention, problem question. So they will paint a problem question, paint it. Then you are to know whether murder is applicable or whether manslaughter is applicable or whether, the accused will be set free. So you see why it's dicey. You see why a very, very, elegant understanding of this topic is concerned. Because if you are not careful, you can just simply convict the person for murder when the person should be guilty of manslaughter. At most, the person may even be free, or you may end up convicting the person. So if you're acting as a judge, acting as a lawyer, your understanding of this, as far as your problem question is concerned, is very, very necessary. So you must make sure you start first of all by reading section 24. I crammed it during my time. I crammed it. So you must cram section 24. On next video, I'm going to tell you further on that. So you must cram section 24. Know everything section 24 is talking about. Then cases, please. That's why I took my time to lift up some cases. If you can you can go through these cases and read the fact. Some are in my some are already in my Law Made Simple website. Just type lawmadesimplelegal.com or Element of Crime by lawmadesimplelegal.com. Just any topic you want to search on Google, you can just type the topic and say Law Made Simple Legal by Law Made Simple. If I have made a post on that, you are going to see further things that illustrate it. So the essence of this is to help you so that you will understand cases that will open your head. So in my next video, please, we are going to discuss recklessness, negligence, and see how it works. Further, we move to section 24. So I hope this video helps you. Don't forget to like. And then for the first video we made, just click this link above. This link, they are going to help you. Those videos will be the one we started and also the continuation, depending on the time you are watching this video. Go there and watch it, or go to the description box and choose any one of your choice. I will see you there.